The rule just changed, and almost nobody's noticed. Not the students it hits hardest, not the employers who hire them, not even a lot of people in the immigration industry who talk about visas for a living. On September 15th, 2026, the clock that governs how long you can stay in the United States as a student stops being whatever your school says it is. And before you file this away as somebody else's problem, hold one question in your head. What exactly is the thing that decides how long you get to stay in this country? Is it your visa stamp, your I-20, your employer's petition, your marriage certificate? Most people have never asked that question out loud, and that's precisely why this rule is going to catch so many of them mid-flight. By the time we're done, you'll know the answer, and you'll understand why it touches you, even if you haven't been near a classroom in 15 years. Here's what happened, translated out of the legal jargon. For almost 50 years, going back to 1978, student visas worked on something called duration of status, which sounded technical, but meant something very simple. You stayed as long as your academic program lasted, and nobody at the federal level ever had to look at your file again as your degree crawled toward completion. Your I-20 said what your program was. Your school vouched for you, and that was the whole system. On July 17th of this year, the Department of Homeland Security published a final rule that kills duration of status dead. Starting September 15th, you are no longer admitted for an indefinite stretch. You're admitted for a fixed period based on the program length printed on your I-20, capped hard at 4 years, plus 30 days to arrive and 30 days to pack up and leave. If you need longer than that to finish work or to begin the next phase, you don't just keep going and hope. You now have to apply to the federal government for an extension of stay. And here's the first twist, the one that surprises people who've been through the system before. The school no longer decides. For decades, the extension conversation happened between you and your designated school official. And if your program ran long, the fix was a new I-20, a signature, done. That entire comfort zone has been moved to U.S. Citizenship and Immigration Services, meaning in practice, a Form I-539, a filing fee, a biometrics appointment, background checks, and a wait measured in months while the agency decides whether your continued presence in the country is justified. The same rule reaches past students entirely. Exchange visitors on J visas and media representatives on I visas move on to the same fixed admission framework. So if your papers run through any of those letters, every word I've said so far is about you. The people who feel this most acutely weren't slacking off. They were pursuing things that structurally take longer than 4 years. Picture a doctoral candidate who passed her qualifying exams, who's 3 years into a dissertation that routinely takes 6, who assumed that finishing was a formality, just a matter of time and chapters. Her time now runs out on a date written by a bureaucrat, and the renewal that used to be a conversation with an advisor becomes a federal application with its own clock, its own fee, its own biometrics appointment, and its own denial risk that sends her entire circle of plans into freefall. That's the student story, and it's the cleanest picture of what changed. But the reversals ripple well past the classroom, and the next scenario is the one quietly terrifying people at work. Say you're on post-completion OPT, or you're on the 3-year STEM extension, and you're doing everything right. Employer-sponsored, payroll taxes going out every 2 weeks, a green card process on a distant horizon. Under the old rules, your practical training rode along inside your student record, and as long as the school kept your CVIS file alive, your work authorization followed. Under the new rules, practical training has to be requested through the same extension of stay machinery. And here's the trap nobody warns you about. If you travel abroad while that's pending, or you leave and come back through any airport, you can be readmitted with a whole new fixed admission date, and you may now owe both an extension application and an OPT application. Paid twice, waiting twice. Even people who file everything perfectly are watching their documents come back with shorter validity windows because the agency has been quietly shortening the life of work permits so it can rescreen you more often. And that is not paranoia, that is the stated policy. But the scenario that breaks my heart a little is the one nobody in these videos ever talks about, the family scenario. Because your status was never just yours. If your spouse is the student and you're here as the dependent, the F2 spouse, your entire standing in this country is derivative. You inherit their permission, their deadlines, and now their fixed admission date on the same day, whether you knew about any of it or not. Picture a family that moved here 4 years ago because one parent was doing a graduate degree. The other parent built a life, volunteer work, a community, 2 kids enrolled in American schools who speak with American accents now. That family assumed, reasonably, that they were covered as long as the degree was in progress. And now the degree is wrapping up, and they're discovering that the grace period that used to cushion the landing, the 60 days people treated like a free month, was cut in half to 30, and that the extension they never thought to file is the only thing standing between them and a very expensive last-minute scramble. The same logic touches exchange visitors and their dependents, because this rule wasn't written about students only. The fixed admission framework reaches across the alphabet of visa classifications. And if your family's paperwork is built on someone else's status, you're only as safe as that person's very last filing. Which brings us to the question you should be asking, which is, why? Why would the government tear up a system that ran for almost 50 years? The official argument, the one in the agency's own announcement, is that duration of status let people stay indefinitely without routine oversight, and that a small minority abused it by re-enrolling in classes forever, the forever student, drifting from program to program, never intending to leave. Whether you find that framing generous or cynical, the mechanics are what they are. The government wants to see you, to fingerprint you, to vet you fresh, every time you need more time, instead of trusting the school's word. And that philosophical shift, the transfer of trust from universities back to federal officers, is the entire rule in one paragraph. It is also, fairly obviously, part of a broader tightening that has been rolling out all year. The separate H-1B rule that landed in February, the premium processing fee increases effective in March, the shorter work permit validity. And if you have watched any of my videos on those changes, you already know the direction of travel. Given all that, the mistakes people are making right now are painfully predictable, and maybe one of them is yours. The first is assuming the school will handle it, that your international student office has somehow been empowered to fix your status like it used to. It hasn't, and the designated school official who once had real power to extend your time now mainly has the power to start a process that ends at the federal government's desk. The second is treating travel as a casual errand. Every departure after September 15th is a chance to come back with a new fixed admission date that none of your plans accounted for. And people are flying home for weddings and coming back to find their entire timeline rewritten. The third is ignoring the sunset dates that govern everyone currently in the system. If you're already here when this activates, you get to keep your current status through the program end date on your I-20 or the end of your approved practical training, but never past November 14th, 2030, which sounds like a distant abstraction until you do the math on a long program. The fourth mistake is the strangest one, graduating and assuming you're home free, when the clock that mattered the most, the 30 days you now have to leave or to file for whatever comes next, is the shortest it has been in decades. And the paperwork it takes to survive that window takes longer to get approved than the window itself. And the cruelest part is that none of this is a surprise. The agency published the dates, the forms, and the fees months in advance. And the only plans that survive are the ones that treated those dates as law instead of rumor. Now, the resolution, because I asked you to hold a question at the start. And here's the answer. What decides how long you get to stay in this country is not your visa stamp, which mostly just lets you knock on the door. It is not your I-20, which now describes a program rather than a permission. And it is not your employer's petition, no matter how heartfelt. It is the admission period on your official arrival record, the fixed date the government writes down when you enter or when you adjust. And the only way to move that date forward is to file, on time, through the new extension machinery before it expires. The exceptions do exist, and they're narrower than the rumor mill suggests. If you're the beneficiary of a timely filed H-1B petition, the cap gap protection still covers you without a separate extension filing. And if you're already in the country and you file your practical training application on time by March 18th, 2027, you get to skip one of the new applications. But those are paths, not loopholes, and every single one of them still runs through a deadline that will not care about your personal circumstances. If you're in this spot, here's what I tell you, the way I tell a friend. Do not wait for your school to call you. Pull your I-20, find your program end date, put it next to the calendar, and count backward from the 30 days. Because that's your real horizon now, not the one you assumed. If you have any filing that's coming, any OPT, any extension, any adjustment, move it earlier than feels necessary. Because the agency that used to be slow is now slower. And the fee structure, the biometrics, the revetting, all of it is designed for a world where patience is a luxury you no longer have. And if your paperwork depends on somebody else's status, your spouse, your parent, your child, sit down together and treat it as one file, because the government already does. The stamp in your passport is for the airline. The date on your arrival record is the law, and those are two different things. This rule is not a rumor, and it is not a forecast. It is in the Federal Register, it is effective on September 15th, and the people who adapt to it, starting today, are the ones who will still be here when it settles. If this changed how you see your own timeline, leave a comment about which version of the story you saw yourself in. And subscribe, because I am already working on the next video, the one that walks through exactly what the new extension application looks like on paper, line by line. And you do not want to be filling it out for the first time on the night before your status expires.